Well, good morning, everybody. Everybody here in the back? Excellent. My name is John Benson, and today I'm going to be talking about the gap between technology and the law. And we're going to talk a little bit about whether it's getting bigger or getting smaller. First, we're going to talk about some of the fundamental differences between the two worlds of technology and the law, and why those differences lead to kind of where we are today with uncertainty in how the law is going to treat things. Then we're going to take a look at some perceptions and adoption of technology and security within the legal community. Then we're going to talk about the Julia Merrow trial and talk about what happens when you have attorneys on both sides that don't at least have a working knowledge of technology to be able to talk about it and actually find the facts the way that they should be. And then, if we have time at the end, I will talk a little bit about what happened last week with the release of the HD DVD decryption key and kind of the response to that. First, who am I? Some of you may know me as jurist. I am an attorney. I work at a very large corporate law firm in Kansas City. And in fact, if you were here at the legal talk yesterday and heard about going through stacks and stacks of documents saying whether or not something is responsive or not, that's my job right now. And it's a good time, let me tell you. I'm also a professor at the Colorado Technical University at their Kansas City satellite campus. And if you want more details on that, I have resumes at the front because I love my job so much right now. Well, first let's talk about the differences between technology and the legal community. As we all know here, technology becomes more advanced every single day. What may be state-of-the-art one day is certainly not the next. And growth and development are encouraged. And how does that contrast with the legal world? Well, sweeping changes in the law are actually extremely rare. It's a common misconception that courts can just simply overturn previous decisions. With the exception of Brown versus Board of Education, which ended segregation, usually you will not see that. And if you do, it is a very big deal in the legal community. The law is slow to react to changes, and I've got to know that it kind of hates things that are new and different. The legal community is always very slow on the uptake of new issues, and we know that just now the Federal Rules of Civil Procedure have officially recognized electronic discovery and codified it. That's all I will say today about the Federal Rules of Civil Procedure to keep you all awake. So why can't the law be different? This is one of the questions that I hear a lot from people is well, isn't there something that we can do to make things work better? Well, the common law system, which has been around for thousands of years, is very stable, and it creates laws that are not in flux, unlike the civil system in continental Europe, where you can have two seemingly identical sets of facts and two separate decisions. Here in the U.S. and in other common law jurisdictions, you can very easily predict what will happen in a future case based on what has happened before. Changes in the law are very slow and methodical. Every case that comes to an appellate court answers one very specific question. And from that one specific question, the one specific answer, there's usually another question that can be asked, but the courts will not deal with that. They only deal with things that come to them. So what does this create when you bring together technology on one hand and the law on the other? Well, we don't know how the law will treat many aspects of technology and security issues. for a couple different reasons. First, in order for very settled upon law to be created, it has to go through the system and to actually reach an appellate court of some kind. And second of all, a lot of cases and a lot of factual situations haven't even been brought up at the trial level. So until those happen, then the questions will remain. Well, let's turn now to how attorneys have adopted technology and what some of their perceptions are of it. And I will say that what I'm going to talk about today is merely anecdotal evidence and things that I have observed in my own area. And I have no doubt that in many other parts of the country, attorneys may be considerably more savvy. But in Middle America, these are some of the things that I notice. Well, who are we talking about when we bring up the legal community? Most attorneys don't have a deep understanding of technology. They simply will use it, but really don't understand it. And part of the reason why is that a lot of attorneys, since they do bill hourly, they would much rather spend their time billing hours instead of figuring out how to use their computer, which is fine. Then you have the bench, and judges, as you can imagine, are even worse. They reach a certain point and have lots of support staff that understands all the technology. Also, attorneys come from very diverse backgrounds. You have people that have undergraduate degrees in political science. You have some that do have backgrounds in science and engineering. But what I've noticed is a good number of those individuals get snatched up and by intellectual property and go and work on patent law and things like this. And what that leaves is a void within the rest of the law, where you don't have individuals who have a deep understanding and are very conversational in technology and security issues. Well, is there hope? What are the new lawyers coming out of school like, and what do they know about technology? Well, for my graduating class, most of us did have laptops. Many states now allow you to take the bar exam on the laptop, which was a godsend for me because my handwriting is atrocious and probably would have fallen off had it not been for my computer. Most use Windows. Most use Internet Explorer very happily, and as I would sit in lectures, you could see Windows kind of popping up here and there, and I also noticed at least at my law school that most students don't really pay attention to what they're sending over wireless connections, and many of them don't have a problem sending all their passwords out in the clear, and a lot of them are very obviously their one password that they use for everything. And those are the youngest group, the group that should be on the cutting edge. Well, attorneys like to adopt technology. They like to use it because it makes their lives easier. They love using email, and they love using BlackBerries. Whenever the BlackBerry outage happened a couple weeks ago, around my firm, people were just frantic. I can't get my email when I'm standing in the elevator. Oh my God! The federal courts have adopted the electronic filing system, which is good. It's very secure, but those are mostly the support staff. It's the clerks that are driving that, and not the judges. Now, we also have to realize that attorneys have a very, very strong affirmative obligation in the rules of professional conduct to keep all communications with their clients secret for privilege issues, work product issues, and it just doesn't seem to work very well together whenever you are using this technology so much. You have an obligation to keep things secret, but you aren't careful and you don't take security issues into account very much at all. In fact, it is attorneys, of course, that brought us this message that you see at the bottom of many emails now. And, of course, my favorite part is the bottom, which is in bold, saying, destroy all copies of this original message. Well, yeah, I'll get right on that and start scrubbing off my hard drive. That doesn't work very well. So what's the obvious answer for this? Well, encryption is out there. At this point, it's easy to use, it's easy to implement, especially for small practices. And it's the small practices that really are at a greater risk for breaking the rules of professional conduct, because they're smaller and they don't have the large in-house IT staff to help them make sure that everything is secure. They also have the most to lose because it's, instead of being a large corporate firm, it's one individual. And most of the attorneys and law practices in the country are firms of 5 people or less. Well, how do attorneys view encryption? After joining the Missouri Bar, I joined a mailing list for solo and small firm attorneys, just to see if I could contribute and help with technology issues where I could. And I always, from my personal email and my official email, I always sign my messages with a PGP signature. And it appears at the bottom of the email, as we all know. And upon making a couple postings on the listserv, I got a message back from one of the individuals who likes to talk about and thinks that the listserv is his own kind of platform to spew all kinds of nonsense constantly. This is the private message that I got from him, saying that thinking that I had encrypted my message that I had sent to his family, being the listserv itself, and clearly thought that because I had encrypted my message, that then the Department of Homeland Security and NSA would be then paying attention to what all is going on. And while that may be somewhat of an extreme example of somebody's misconceptions about security issues, I think it's probably pretty common, at least in my area. Now, when we talk about the smaller firms and the guys that are out on their own practicing, these are also the ones that are going to be doing a lot of trial work. Not necessarily the big, large-scale litigation involving truckloads and truckloads of discovery, but dealing with criminal law, for example. Obviously, they need excellent advocacy skills, and they need a working understanding of the facts. Attorneys deal with issues, factual issues, of a very broad range, and usually they can find a working knowledge, at least to be able to explain to the jury kind of what's happening. But when it comes to computers, it seems like there's this knee-jerk reaction to kind of waller in your misunderstanding, which we'll see from the Amero case. And these are the exact people that need to be conversational in technology to make sure that when we are creating this new body of law, that we're creating good law and law that is logical to the rest of the security and technology communities. Well, let's talk about the Amero trial. I'm sure that you've all seen a good deal of coverage about this. It was a substitute teacher who came in to a school in Connecticut, and during the day that she was there, she started getting pop-ups on her computer, and those pop-ups had pornography on them. And throughout the course of the day, some of the students in the class came up towards the computer and saw some of the pornography on there. And oddly enough, these were not 6, 7, 8-year-olds. These were 11, 12-year-olds. the local prosecutor decided that a good use of resources would be to prosecute this lady. And let's first take a look at the statute that she was charged under, because there's been a lot of willful blindness, it seems to me, on the part of the security community who came to her defense so vocally as to, what was she actually charged with? Because we have to take a look at that before we go making judgments on what the jury itself found. The statute said that you could be punished if you willfully or unlawfully caused a child under the age of 16 years old to be placed in a situation where the morals of that child are likely to be impaired. That's what we like to call a vague statute. And willful means intentionally or deliberately. It's not a negligent statute. Some of the coverage in the local paper made it seem that she should have been punished because she didn't act reasonably in protecting the children. She didn't turn off the monitor. She didn't jerk the plug out on the computer. And while we all understand that, we have to realize that there are people out there who have seen the warning from Windows all the time that it is now safe to turn off your computer, and that a lot of people assume that if you don't see that little message, then you can't turn off the computer. So while yes, it does seem very logical to us and certainly to parts of the media to just shut off the monitor, it's largely irrelevant under the statute that she was charged under. So let's take a look at some of the highlights from the trial transcript. The local newspaper was good enough to release the trial transcript for everyone to take a look at. Here's some of the quotes on here, taken directly from the trial transcript from the prosecutor. Were there any other images that had been placed on your hard drive on that day before you at least saw it, at least in the file format? What is that? Seriously. Then, did she log onto any programs? Okay. And there are many opportunities to kind of laugh as we were going through here. I'm sure that the prosecutor was as giddy as I was to cite this website in open court. Specifically to what I'm pointing to here, my understanding is that this, vaginalcumshots.com, specifically this website, again, was access to that PC in Mr. Knapp's classroom. Now, we also have the defense attorney. And the defense attorney, in this case, certainly needed to do as much as he possibly could to help Ms. Amaro out and keep her out of jail. And it's as far as trial advocacy goes, and the techniques that we all are trained to use in school, I didn't see very many of them in this case at all. But that's beside the point. That's for a different talk. These are some of the questions. Were any of the adware, spyware, parasite, and viruses updated on or before October 19th, which is when this happened? Once again, what? And that was actually a question to the school's head of IT. Yeah, I think it was no. So, and then finally, in the closing argument, as if we couldn't figure this out before after reading 340 pages of the trial transcript, he comes out to the jury and says, "I'm completely computer illiterate." And while that may kind of bring the attorney down to the level of the jury and make them sympathetic to him and his client, that's not creating good law. That's not good advocacy to say that you are completely illiterate in the subject that you are litigating. Well, let's take a look at some of the pitfalls in the handling of the evidence. First of all, when the reports came to the principal and the superintendent of the school, they sent the head of IT to check out and see what happened. Did he first go to the server and check the logs? No, he went right to the computer and opened up the temporary internet files and saw what happened the day before. On top of that, the computer stayed in the classroom and continued to be used for more than a week before it was seized by the police. And all that evidence was still allowed to come into the trial. The police investigator was asked this question: did you examine the hard drive for spyware, viruses, or parasites? Whatever parasites are. And the answer was no. It wasn't. All he did was take a look and see what images and what websites had been stored in the temporary internet files and in the history. That was all. No kind of virus scan, no kind of scanning on the computer whatsoever. And in considering that the statute says that she had to willfully and intentionally access these websites, he completely ignored the possibility that that this could have happened unintentionally. Was that his job? Yeah, I believe so. I mean, if you're going to be doing forensics on a hard drive, you need to collect all the information. The prosecutors are required to give over any exculpatory evidence to a defendant, and they certainly didn't do so in this case. I don't know, but it's certainly underhanded. And say what you will about attorneys, about underhanded acts of attorneys. I think it was just pure ignorance on their part. Right. Yeah.
Yeah, but the defense should have credited methodology and the police work on cross-examination.
The cross-examination is a complete mess. Personally, I probably could have done the cross-examination in about 3 sentences and been done with it. And it just kind of drags on and on and on, and no real good facts come out of the cross-examination of this individual as far as impeaching the evidence that they had.
Plus, you also said that they did check the firewall logs. Often that'll show you the infection coming in.
Yeah. They checked the filtering so they could see that the websites were accessed, but they didn't see any of that. But now that we talk about checking the logs, let's talk about the individual that was in charge of computers there. The district, and he very clearly said this in court, the district runs Windows 95 and Windows 98 machines, and this is just a couple years ago. They only had antivirus protection, no kind of other anti-malware protection on there at all. And he did say that there was filtering software installed district-wide, but they didn't update it. In fact, they didn't renew their license. And it's unclear to me, and from the trial transcript, it's murky as to whether the filtering software stopped working when the license ran out. But he clearly said that it wasn't updated. And had he updated the software like he was supposed to and done his job, then none of these websites could have been accessed either intentionally or unintentionally. This is a question to the head of IT for the school district. Does spyware and adware generate pornography? I'm not aware that they do. I don't know if he's ever been on the internet, but so why was some of the evidence excluded? What happened, and this is also kind of, I put this on the security community that came back so strongly. They were angry that it was just a procedural technicality that kept a lot of the evidence out. Well, making sure that the other side knows what evidence is going to be presented is not just a technicality. The way the trials work, you always exchange the evidence. You know what's going to happen. There is no kind of Perry Mason moment where you have the surprise witness or surprise evidence come in. There are no surprises in trial unless they come out of the witnesses' mouths. Everybody should be on the same page, and I believe that the prosecutor was absolutely right in objecting to the evidence because he didn't have a chance to see what was going to be said. He couldn't prepare to effectively cross-examine on evidence that was just then being brought to his attention. And would it have made a difference had he been able to give his PowerPoint talk to the jury? Would it have made a difference? And I don't really think so. The judge did not preclude him from saying adware or spyware or anything like this within his testimony. He brought these facts out, that he believed that this happened unintentionally on the part of the defendant. And in fact, the prosecutor, in an example of tremendous trial advocacy, was cross-examining, doing a recross of the expert witness, and he asked him straight out, "What is your conclusion about this case?" I don't know if you know anything about cross-examination, but the idea of just asking an open-ended question like that, you shouldn't do that because you don't know what's going to come out of the witness's mouth. And the expert did exactly what he should have, and he said it wasn't her fault. It was caused by the adware and the spyware. So his conclusion did get into court and was heard by the jury. But let's talk about the expert. He was extremely rude to the judge and spouted off on numerous instances that he thought what was happening was wrong. After a long, drawn-out objection, he was asked a question, and he told the person that was asking the question, "I don't think I can answer that." And the judge, even though you're reading it, you can tell that in a very fuming voice said, "You answer the questions that are asked. I will tell you if you can't." And the expert witness certainly didn't do a very good job of building any kind of rapport with the jury or with the judge. So who do we blame for the wrongful conviction here? Blame everybody, if you ask me. We blame the district for not maintaining their technology correctly. We blame the state for bringing this case in the first place. In my opinion, it was absolutely ridiculous to use so many of the state's resources to wrongfully prosecute someone. The defense attorney was, by his own admission, computer illiterate. He had very little business handling this case, in my opinion. And the expert as well, because the expert did not make his materials available to the defense attorneys to then give to the prosecutor. An expert witness needs to be an expert at being a witness, needs to understand that we get my testimony out ahead of time, we make sure that everything is set to go, and you certainly don't yell at the judge and tell the judge that what they are doing is an airplane crash, which is what he said to the judge during an objection. That didn't happen in the trial. It may have happened afterwards, but no, I didn't see that in the transcript. So the response from the security community, was it warranted? There was a lot of shouting that this was a failure of the jury system and just going on and on and on. But you need to take a look at the statutes and the procedure and have a respect for the system. Just because you believe that the overall outcome is wrong, unless you understand the process behind it and how you got there, it's probably a better idea to read up on it. Find out exactly what happened before you go making a big deal out of things like this. The two communities, the legal community on one side and the security community on the other, need to come together and really need to work to make sure that we have laws emerging that do make sense. And blind rage against attorneys and the courts isn't going to do any good at all. Well, now let's talk about what was the verdict? She was convicted of 4 counts of under the statute. I don't remember. I believe the sentence was pending, but she faced up to 40 years in prison. I believe there will be appeals forthcoming. I don't know on what basis, though. Ineffective assistance of counsel is it's harder to bring than you would think. And him saying that he is computer illiterate on its own, I don't believe would be enough to qualify as ineffective assistance of counsel. Certainly in this room, we all believe that it would be. But I don't know if the courts would. Well, he certainly wasn't a powerful presence in the courtroom, I can imagine. But that alone would not render him ineffective. Well, then let's turn to what happened last week and the release of the HD DVD processing key. Well, it was released weeks ago, but it kind of came to a head last week whenever it appeared on the website dig.com, and Dig received a takedown notice under the DMCA, and they had a choice to make. Do we take it down, or do we fight the takedown notice? They did what they thought was right in that situation and took it down. They did not, however, explain to their user base the reasons that they were taking it down, and they did not try and justify their actions saying we are legally obligated to do this, and that's what we're going to do. Well, the user base of dig.com then decided that this was censorship and this was wrong and this was a constitutional issue, and therefore decided to flood the website with the key everywhere. And the key has been posted on so many places on the internet. I believe that one of the stats that I read yesterday was that the key has been accessed at least 2 million times. But let's take a look at the facts and whether what Dig chose to do was correct. Dissemination of this key is a violation of the DMCA. Whether or not you think it is ridiculous that you can copyright works, or whether or not the DMCA is good law, which it, in my opinion, is absolutely not, it is the law that we have. The Digital Millennium Copyright Act. The takedown notices were valid, and it's not a First Amendment issue. If you're going onto a privately run website and you decide and they decide that they object to something that you're doing, they can do whatever they want. We're private parties here. You're not entitled by virtue of it being on the internet to do anything that you choose just because you're on the internet and sitting behind a keyboard.
Where do you draw the line? I mean, that the key is it's not source code, right? So I can't put the fine on my skin or on my website because it's in source code and somebody wants to serve me with a DMCA violation?
Oh, well, no, I 100% agree that it's ridiculous. But it is a component of something that can be used to circumvent copy protection. And it's still a violation. And from the way I look at it is what an individual wants to do. If I wanted to post the key on my website, and in the spirit of civil disobedience, then that's perfectly fine. But to expect a third party to acquiesce to something that you believe and therefore put their financials at risk is completely arrogant and completely immature. I don't think that I think Dig did what they had to do, but they could have handled it better. What they should have done was explain why they had to do it, and then see what happened. And if and this is something that with the new user content-driven sites, that it's something they're going to have to learn to deal with in the immaturity of your user base. If they're going to refuse to comply with the law and they're going to put you at risk, then feel free to pull the plug on the site. As soon as it just started filling up and filling up and filling up, they could have just jerked the plug. So, but let's talk about the reality on the other side. I'm certainly not defending the takedown notice or anybody acting under the DMCA. The AACS needs to realize that this is Pandora's box. Once it is out, it is out. And there's a lot of talk of them tracking down all the individuals that posted the key and taking action against them, whether it's a stern letter or whether it's a DMCA takedown notice or filing suit. That's not going to help the situation, and it's not going to make users worldwide feel any better about the technology being in existence, and it will just kind of rile up the crowd even more. But user-driven sites need to realize that if they are served with something like this and they do plan on complying, they need to have some sort of plan in place to deal with that and to deal with a user base that is going to have a good amount of backlash against that action in the first place. Well, the fundamental issues separating law and technology that we talked about at the beginning, the fact that the common law system is very incremental and very slow to respond versus technology that changes day to day, it's not going to go away. And we certainly don't need more laws. We don't need legislators writing any more laws like the DMCA or laws that are incredibly vague. We need to start building the body of law. And the attorneys who are going to be there on the front lines need to have a better relationship with technology. They need to educate themselves on how to use it properly. They need to educate themselves on how it works before you go into court and admit in front of everyone that you are completely computer illiterate. And we really need stronger advocates in the courts that have technical backgrounds going into trial work. There's a lot of money in intellectual property. I'm not going to lie about that. But the real need at this point is in building the law from the ground up. So, are there any questions?
You said what students of law do with computers. You didn't mention that they download illegal MP3s.
I've heard rumors of that.
Is that eventually going to start changing the law or making it illegal?
I don't know if it will or not. I mean, it's the fact that young attorneys are doing it probably won't make much of a difference. I think that certainly there will be more and more people viewing lawsuits by the recording industry against individuals as being completely ridiculous and completely ineffective. But at the same time, when an attorney goes to work for a firm that represents the recording industry, you've got to do your job. Otherwise, you're going to lose it. And in the rules of professional conduct, there is a rule that says attorneys, by representing a client, do not necessarily agree with what they're advocating. They're advocating the position of the client and don't necessarily believe in it.
Is Dig going to be on the hook for all those copies of the key on that site? And if so, do they have any defense against it?
That'll be interesting to see. They got the takedown notice and they took it down and then lost the fight against the users and said, we'll go ahead and try and fight this. But this is something completely new. Civil. Certainly civil.
There was a case like a year or two ago about libel not being, about forum operators not being responsible for libel posted on their site by users. Would that have any impact on this? If it's coming from the user community and not the owner of the site?
I think that that argument certainly would be made, and it's probably a pretty good one. But the argument on the other side is, hey, you could have pulled the plug on the site once you saw what was happening. That's that's up in the air. I don't know. I haven't put a lot of thought into that. What do you think? It certainly would. All right. Oh.
How about companies that cache, websites and archive up? Now some of that's going to store on there as archives.
Like they had
Yeah, I think those things were.
2 million plus hits on Google last time I checked.
Yeah, so I mean, was there responsibility, to take initiative on their own or just wait for,
I don't know. It would be up to the operator whether they're willing to bear that risk or not. They know that the takedown notices are coming, and clearly the organization has made it clear that they're going to keep them coming. And just like with retaining documents, if you can reasonably anticipate litigation, it's reasonable to expect that you're going to get the takedown notice. So if you want to fight it, go right ahead. But at the same time, you've got to be realistic. And you've got to realize that eventually, over a number of years, the law will fit with reality. I think we're seeing the reality kind of catch up with the idea that leaving your access point unencrypted and open to the world as a defense probably isn't going to be that effective. Trying to get cute with the law doesn't work out well for anybody.
But isn't it going to require somebody to fight it to make that catch up actually happen?
Yes. Yes. So somebody's going to have to bear the expense. Well, all right. Well, I thank you all for coming out early in the morning. And I'll let Major get up here and get his talk started.